wish to welcome everyone to this 9th edition of the Courts and Society webinar series, which is a global platform in which different actors and intellectuals, academics, students, the public interact on very important themes relating to the judiciary and how it works, and other different actors within this sector work. It is hosted by the AET Socio-Judicial Consulting, which is a research-based consulting firm, and I'll introduce it just now. My name is Sibonile Khoza. I'm a practicing advocate. I am based in Cape Town. I am an admitted advocate at the High Court in South Africa, which is where I come from. So the theme of today really is close to my heart because of the interaction I have with the bench. So today's theme is focusing on sustaining judicial integrity and looking at combined efforts of the bar and the bench. Your host facilitator is none other than Dr. Ari Niki-Tobi, who is the founder of the consulting firm that hosts the webinar. Her CV, which is quite long, but I tried to cut it down. Otherwise, we'll be here for too long. Her bio is as follows. As I've already mentioned, Ari is the host or the founder of the consulting firm. She has obtained at least 4 legal degrees, the first being a junior degree, which is an LLB. After about 2 decades of research on courts and society, Ari propounded her socio-economic theory of justice and initiated this unique court and society webinar series, which brings together judges, intellectual students, the public, lawyers in general, from various countries to share their intellectual views and build intellectual relationships and discuss socio-judicial concerns that affect or impact judicial development. Through the webinar series, community platform that has been created, Ari serves diverse groups needs in her community, a criminal justice platform that focuses on training police officers on community policing, a platform that gives children civic education, and a platform that celebrates women judges from various countries around the globe. Ari's passion for social justice, as we know her, and advancing judicial jurisprudence is evidence in diverse peer-reviewed publications and presentations at various national and international conferences. Ari is also a reviewer of the International Journal for Law and Society and has held chair and discussant roles in several international conferences. Ari is committed to social justice and to community development, and she's an active member of several boards in her home community in New York, where she is based. Ari is the first Nigerian and African woman to earn a master's degree in judicial studies. Also, the Journal for Blacks and the University of Nevada, Reno, recognized her as the first Black woman to obtain a PhD in judicial studies in the US. That is the short bio of our host and facilitator of this session today, to whom I would like to give this platform to further run the program of the day. Over to you, Dr. Ari.
Thank you, Sibonile. Good morning, everyone. Thank you so much all for taking the time to be here. I am excited, very excited, particularly because our keynote speaker had to bend backwards to be here. I have tried to get him for a long time, but when someone is good at what he does, it's difficult to get the person. So I really totally thank everyone that is here. I would just follow the protocols usually the Nigerian protocols, I want to be sure, I was going to check through to see if there are any Chief Justices in attendance or any Justices of the Supreme Court. Usually we take that protocol, but I don't see any, so I will just go on with the keynote speaker, Honorable Justice Kashim Zana, the Honorable Chief Judge of Borno State, Nigeria. With all due respect, I think I breached protocol. We have a appellate court judge here, Justice Biobele, Judge Will. So I would take that protocol again, forgive me. The Honorable Justice Biobele, Judge Will, Court of Appeal Judge of Nigeria. The Honorable Chief Judge of Lagos, of Borno State, Honorable Justice Zana. And all the other speakers here present. We have members of the bar, professors, honorable speakers. Thank you so much for being here. Thank you for going out of your way to prepare for this event. Senior advocates of Nigeria here present as well. Thank you. So brief protocol for those who would be joining us shortly. We have over 100 people registered, but usually we have issues with the time. So a lot of people forget. And if you don't send reminders, they log in maybe 20 or 30 minutes after the program because of the time difference. So would please kindly respect the presence of distinguished justices and from different courts all over the world. So we would observe, I beg your pardon, judicial protocols. Remain muted until you're granted permission to unmute. Please turn off your camera if you're busy so you avoid distraction, and send your questions to Sibonile Koza or myself. A brief history of the Courts and Society webinar series. The first of its kind webinar series started April 25, 2022. Was birthed from the late Honorable Justice Niki-Tobi Biennial Symposium. And from that symposium, we had different sessions, and we broke those sessions the following year into webinars so that we would be able to address these topics and not just talk about them, but break them into small sections where people can actually address issues and it will be more impactful. Accordingly, we honor the legacy of the late Honorable Justice Niki-Tobi, who, for me and many others would agree, stood for justice, integrity, altruism, and diligence. And of course, through his writings and judgments, we can see how he, particularly I, who had a very close relationship with him as a mentor of mine and father, that he lived, for me, is the face of the court and society, one who was very strict as a judge, but also a very simple man in the society and was very committed. So this 9th edition will be celebrating, as we celebrate judicial jurisprudence of different countries and speakers from all over the world. We will be celebrating the jurisprudence of Nigeria, the United States of America, and the Netherlands. We started with a topic on the impact of judicial precedents on societal development, and after that, we discussed the courts as agents of social change, impact of judicial education on developing law and society, the court's role in advancing human rights in the diversified world, the court's role in Nigeria's electoral process, women judges' impact on society and democratic development, celebrating an icon of justice, Honorable Justice Amina Adamu Augi, a retired justice of the Supreme Court of Nigeria. We also talked about judicial ethics and social impact on judges, the Buga controversy. And the last one was the impact of public opinion on judicial integrity and democratic development. And as we do, when we have the Honorable Justice Niki-Tobi Biennial Symposiums, we bring out the symposium, the Court and Society webinar series for the next year based on the symposium of the previous year. So the second Honorable Justice Niki-Tobi Biennial Symposium that was in person in Abuja, Nigeria, discussed the clarion call of judges in democratic development. And out of that, we broke down the sections into webinars this year, as we see. So the late icon, Honorable Justice Niki-Tobi, did say of a judge, that his public actions and utterances are watched by the entire populace and not only by the litigants who are his immediate clientele, so to say. As a judge, his actions or inactions are on trial. While by the very nature of his humanity, he is a human being, the public looks at him as a superhuman being who cannot and should not commit any rage or outrage. That's in his book, The Nigerian Judge. So today we just, celebrate the judiciary of the United States of America, the Dutch judiciary, the Nigerian judiciary. And we hope and we pray that they would live in justice and in truth, that the society will understand the impact of the judiciary in these countries. So the preamble of the Code of Conduct for Nigerian judges says, and I quote, "An independent, strong, respected, and respectable judiciary is indispensable for the impartial administration of justice in a democratic state." Canon 1 of the Code of Conduct for the U.S. judges also states, and I quote, "An independent and honorable judiciary is indispensable to justice in our society. A judge should maintain and enforce high standards of conduct and should personally observe those standards so that the integrity and the independence of the judiciary may be observed." The United Nations Office for Drug and Crime Judicial Ethics Training Manual that introduced and kind of suggested the Bangalore principles to Nigeria in various aspects that supported Nigeria applying that principle. I have this to say in a commentary. Social contact between members of the judiciary and the members of the legal profession is a long-standing tradition and is proper. Since judges do not live in ivory towers, but in the real world, they cannot be expected to sever all their ties with it upon taking the judicial oath. Nor would it be entirely beneficial to the judicial process for judges to isolate themselves from their colleagues in the legal profession. Indeed, a judge's attendance at social functions with lawyers offers some benefit. The informal exchanges that such functions allow may help reduce tensions between the bench and the bar and alleviate some of the isolation from former colleagues that a judge experiences upon elevation to the bench. However, as a matter of common sense, a judge should exercise caution. As I don't mean to demean the position of the bar or the bench or be disrespectful, but somehow I see it as a Tom and Jerry kind of relationship where there are good, bad, and ugly moments. And I'm hoping that our speakers would be able to help all of us, though from different jurisdictions all over the world, we have one and the same problem. And believe it or not, even after schooling for 6 years in Reno, Nevada, the American judge, that I experienced over 200 American judges in different class platforms, and it's the same thing. The same personal struggles, the same judicial struggles, the same societal political struggles. Our keynote speaker, the Honorable Chief Judge Kashim Zana, OFR, is an impeccable, incorruptible, indefatigable, ingenious techie. An exceptional attribute and contribution to the Nigerian judiciary, to the African judiciary, as a matter of fact. For me, it's a thing of pride, like I said, to be introducing him and to have him agree to be here after several appeals. I have a feeling that he had a passion for the late Honorable Justice Niki-Tobi, and that was one of the reasons he decided to be here, even though it wasn't very convenient for him. He had a very, very busy schedule. Is the head judge, as is known here in the US, and Chief Judge of the Borno State Judiciary of Nigeria. He has been CJ since 2006. He was a former prosecutor and he rose from the Magistrate Court to the High Court, eventually became the Chief Judge since then. He is passionate about judicial integrity, education, and leveraging technology for the optimization of justice dispensation. His lordship is passionately active in various international bodies. He's the president of the Commonwealth Judicial Education Institution and chairs the Judicial Information Technology Policy Committee of the National Judicial Council. He sits as the board of the UN Global Judicial Integrity Network, the International Society of the Reform of Criminal Law, the International Institute for Justice Excellence, The Hague, and the Judicial Panel of Lawyers Without Borders. You see his hands are full. Of course, he still presides in court and does administrative work as a judge in Nigeria. Under his leadership and initiative, the Borno State Judiciary has consistently ranked #1 on the Pace of Justice Index survey results of Citizens Gavel and Osiwa survey. Validating and vindicating Gavel's ranking, there was a correctional facility survey in Borno State that has shown that in about 10 consistent years, now they have recorded no congestions in their prisons. On the contrary, the report has had vacant rooms in the prisons. Awaiting trial inmates ratio to convicts keeps falling, and the latest report having it as less as 20%, as against the 60% and above prevalent nationwide. His Lordship is a recipient of the Medal of the International Society for the Reform of Criminal Law and the Distinguished Service Award of the United States National Center for State Courts. I will go on and read all the others and then have my Lord take the floor. The second, Judge Cindy Tara, is a judge of Ancaster's Court of Appeals. She began serving at the appellate bench in January 2023. She was appointed circuit judge in 2005 and again in 2007. She was elected to her first judicial term in 2008. In May 2019, Judge Tara became the first female judge in Arkansas to obtain a master's degree in judicial studies, and she served 17 years as a circuit judge. She and I, we had classes together, as a matter of fact, and we graduated together in Reno, Nevada. Judge Tara is the president of the Arkansas Bar Foundation and an active member of the American Law Institute, I beg your pardon, as advisor for the Children's and the Law Restatement, and was previously a member of the Members Consultative Group on Sentencing. She just completed her second term as an investigative panel member on the Arkansas Judicial Discipline and Disability Commission. She has also served the Arkansas Bar Association in several capacities as a member of the Board of Governors, parliamentarian, and tenured member of the House of Delegates. Presently, she serves as the Arkansas Judicial Council Supreme Court Liaison and Retirement Committees. Judge Tara spends her non-judicial time serving her community in diverse areas. She served as the first female president of Kiwanis of Jonesboro, a former member of the Professional Advisory Council of Arkansas Children's Hospital, a former member of the board of the Northeast Arkansas Charitable Foundation, one of the early board members of the 2nd Judicial District Court-appointed special advocates, and former chair of the Arkansas Continued Legal Education Board. Mr. Jibril Samuel Okutekpa, Senior Advocate of Nigeria, is a co-founder of Agama Okutekpa and Company Law Firm, now known as J.S. Okutekpa SAN and Company. He was elevated to the prestigious rank of Senior Advocate of Nigeria in 2011 as the sole appointee from Kogi State, Nigeria, conferred with this honorable rank. Led SAN advocates for purity of justice and believes that judgment rendered without justice is injustice. Leonard SAN is a dedicated member of the Nigerian Bar Association and has held several leadership positions in the NBA Makurdi branch as Financial Secretary, Publicity Secretary, and the first Vice Chairman at different times. He was also a chief prosecutor for the NBA, Nigeria Bar Association, at the Legal Practitioners Disciplinary Committee of the Body of Benchers. Leonard Okutekpa SAN is currently a member of the National Executive Council of the NBA, a member of the International Bar Association, the American Bar Association, the Commonwealth Lawyers Association, and the African Bar Association. He also served several terms as a member of the Body of Benchers. Leonard SAN is considered an apostle of adherence to the legal profession's code of conduct. He has received various awards of recognition, including the NBA Presidential Award for Meritorious Service to the Bar. He is a highly respected authority and conference speaker, particularly on criminal and civil procedures in Nigerian courts, litigation, and ethics. He is also a notable analyst and commentator on legal and national issues, and recently judicial issues on courts, who regularly features at press conferences. He is a published author of journal articles and books which are reference materials in the legal profession in Nigeria. Mrs. Maria L. Washman, Esquire, is an active litigation attorney and founding member and partner in the law firm of Schwer and Washman, LLP, New York. A practice focused on representing seriously injured victims of medical malpractice, wrongful death, automobile accidents, accidents involving utilities, construction accidents, slips and fall accidents, and all others. She also regularly represents clients pro bono. Ms. Watchman currently serves as the president of the Women's Bar Association of New York State, WABOSNA, which holds United Nations NGO status with the UN Department of Public Information. WABOSNA is known as the largest statewide women's bar association in the United States of America. She also served in various positions in the Brooklyn Women's Bar and other bar associations. Ms. Washman and her partner, David M. Scher, Esquire, are very proud of their recent work in San Miguel, San Miguel and Grimaldi et al., a case where the Appellate Division First Department decided in May 23, 2024 to change the status quo for women in the state of New York and rule that a mother can recover for emotional injuries in pursuing a lack of informed consent claimed even without an independent injury. Dependents moved for leave to appeal to the Court of Appeal, and those motions were granted. Ms. Washman is the president of the Women's Trial Lawyers Caucus Incorporated and has been a member of many judicial screening panels, including panels to fill the last 6 vacancies on the New York State Courts of Appeal. She has served as first vice president, treasurer, and parliamentarian of the New York State Trial Lawyers Association and is a member of its board of directors. In addition to WABOSNA and all the other bar associations and organizations, Ms. Washman is a member of the American Association for Justice, the New York City Bar Association, and the New York State Academy of Trial Lawyers. The last but not the least is Dr. Philip Longbrook, Professor Emeritus. He's a member of the Montaigne Center for Rule of Law and Administration of Justice. He contributed to the debate on the methodology of legal research. As an active participant in the International Association for Court Administration, he organized seminars, and still does organize seminars, where professionals and academics could exchange information on desired research. Furthermore, Professor Longbrook delivers guest lectures on management in court administration regularly. He taught Dutch administrative law, public administration, court administration, methodology of legal research, legislation, constitutional law, and administrative law for many years. He published widely on administrative law, ombudsman, and on justice and court administration. Although he is emeritus, he still supervises PhD students. Dr. Longbrook researches court and justice administrations. He organized and directed several international comparative research projects, including a project on legal and judicial training in Europe, a project on cash flow management in civil procedures in Finland, an Institute for Research of Judicial Systems in Italy research project on performance measurements in judiciaries, and he has also participated in projects that enhance the well-functioning of judiciaries of Ukraine and Greece on procedural guidelines and judicial ethics. Dr. Longbrook played key roles in several peer-reviewed journals, the editorial board, including the editorial board of International Journal for Court Administration, directors of the AGPA study group on justice and court administration, the editorial board of Utrecht Law Review. He is presently a member of the, now I went on the internet to try to get this, and I don't know how I'm going to call this name, but you will please forgive me. Justice for John series of Stampfli Verlag in Switzerland. Ladies and gentlemen, I give it to the Honorable Justice Kashim Zana, I beg your pardon, to give his keynote, please. My Lord.
Thank you very much, Ari. As we say in Nigeria, all protocols observed. I'm not a stickler for protocols.
I noticed.
Honestly. So forgive me, and I'll rather save time. I've seen us taken half the time at observing protocols at events, and I wonder whether that was time well spent. Sorry. Now, I've been invited to speak on judicial integrity, but from what I gathered, this stemmed from the concern of the waning public confidence and trust in courts, not just in my own country, Nigeria, but I think across the world, in many jurisdictions, there is this reality of waning public confidence in the courts. Indeed, a study I will refer to, a survey I will refer to in the US, has it that it was the public trust and confidence was at 62% in the year 2014 and came down to 46% in the year 2023. That should be concerning. It's not different here. The dynamics may be different, but in the end, it's a question of waning public trust and confidence. If you just confirm, Ari, that my screen is seen, I will proceed.
Yes.
Good, thank you very much. So,
is everybody else seeing the screen?
Yeah, I can see it from my side.
I'm seeing it.
Thank you, sir. We can see it.
So I've decided that for us, for our discussion to make sense, since it is in that context we're talking, I would just rather cut out, because the integrity topic is a really wide one and vast. But what should be of concern should be the challenges in building and sustaining integrity. With the time slot, I may not be able to do much justice to the topic, but I hope to provoke discussion centered around really positive outcomes that may result in addressing this waning confidence in our courts and our justice systems. Now, good. I'll just briefly underscore the fact known to all of us that doing justice requires certain qualities in the judicial system and in individual judexes or in individual judges. I will hazard to say that integrity is foundational. Of all the qualities, it's the one quality, the absence of which makes every other quality useless, practically useless. In fact, I would hazard even dangerous. We have other qualities like knowledge of the law, judgecraft, and other skills and qualities. But all these come to naught where the judge lacks integrity. Indeed, I said it can even be dangerous. Knowledge of the law and judgecraft in the hands of a judge or imbued in a judge who lacks integrity will only serve to mask injustice and masquerade it as justice. So you rather have a judge who lacks integrity to lack the other skills than to have them, because it's not going to serve justice. Now, integrity, the reality of integrity is important, certainly, but the perception of it is equally important. That's why I said integrity must not only be there and prevail, but must be seen to prevail. It's not original, as you know, but all as lawyers, we're all aware of the time-honored saying that justice must not only be done, but must be seen to be done. And where that integrity prevails and is not seen to prevail, then justice would not be seen to be done. So, but there is a difference between reality and perception of justice. And many a times, the public confidence and trust is shaped more even by the perception of whether the integrity prevails or not than the actual prevalence or deficit in integrity. So perception is really important. Justice is rooted in confidence. And therefore, where even if it's wrongly perceived that the judicial system or the individual lacks integrity, then it's a serious matter that just has to be addressed. Now, what shapes perception? So many of them. I've just outlined broadly one just for the sake of discussion. But when you go to the shapers of perception, it's a real vast field. Of course, one of it is reality itself. Lived experiences shape perceptions. I have the bar there because one of the topic actually says a joint responsibility of the bar and the bench and the judiciary. Now, you may notice in the logo that the bar, the icon there is more like the pub where you take drinks, but actually the pun is intended. Both the formal bar association as we know it and the pub shape perception. So the pun is intended. And the role of the bar cannot be overemphasized. There are other reasons why the public may perceive the judiciary or an individual judge as lacking in integrity. But where the bar steps in some instances to explain that it's not want of integrity. For example, this decision that does not go down well with the public perception or with the public's understanding is actually what the law requires the judge to do. That helps in building the perception. But I've particularly singled out, after mentioning the media, the high-pressure media campaigns, the publicity given to cases, rightly or wrongly, all these end up shaping perception. But I've separated social media from just the media general because this is perhaps one phenomena that explains the waning perception of lack of integrity in judiciaries across the world. With the liberalization and democratization of the source of information and dissemination of information, we've come to the stage where a hardly informed person on his mobile phone can shape perception and can talk about the judiciary in a way that goes viral within minutes and is trending, and then they build up to this thing. So these are all shapers of the perception that end up with whether the public perceives the judiciary or individual judges as having integrity or not. Now, the challenges, of course, that these are challenging areas. How do you address these things? I've talked about the bar in passing, that yes, they can help by explaining, but it's not in all circumstances. How do you actually measure integrity? Because in anything, you have, once you can measure it, they said you sort of have the problem. And integrity is not amenable to easy measurement. Do you scan for integrity? Institutional scans have been developed, but how do you scan the individual judge to say whether he has integrity or lacks integrity? Do you scan the brain? I mean, it's part of the challenges. There are ways around it. I hope we can go to those. Now, again, do our systems really have a way of determining integrity in the individual judge or in courts and rewarding integrity? I'm yet to see any system developed whereby this institution actively seeks out, and it's a difficult one, what we have is we punish where it becomes obvious and apparent the lack of integrity, which in itself is very difficult. It's a process whereby proof beyond reasonable doubt is required before you say this judge lacks integrity, and then he's punished. But how do you now also say, because for you to entrench integrity firmly, you need a process whereby, at least theoretically, whereby integrity is rewarded, and that drives human beings, motivates the human beings who are judges to have this quality and to improve upon it. So these are the challenges in first building integrity and also in sustaining it where it obtains or where it is prevalent. Further to the challenges, there are some manifestations, or rather obvious manifestations of lack of integrity, but are really have really other underlying reasons and may not actually be deficit in integrity as we perceive it. And particularly one that I've, out of my experience as a member of the National Judicial Council, whereby we consider petitions against judges with allegations of that touch on their integrity. We've found that in some of these instances, it's really the issue of ethical dilemmas playing out, the choices. It's not, judges are not confronted with good and bad to choose one from. They really, in many cases, confronted with either good and good, so which one is better, or bad and bad, so which bad must I choose? And you have to choose one. And the call is yours to make. So this is just a really simple way of putting the ethical dilemmas, but I'll go to, before I end up, I'll point at where this issue is professionally taken and considered and addressed. Then there are other underlying issues or illnesses, if you forgive the pun, that also underlie some of the manifestations or where the presentations of deficit of integrity. And these are judicial well-being issues. We've for long, all across the world, ignored this issue, but really at the Judicial Integrity Network Group, we took a look at this thing, did a survey, and the issue is now much more serious than hitherto thought. And I also refer to that one. There are well-being issues across the world when it comes to judges. Now, I will take particularly the dilemma issue and the well-being issue, but there are others too, whereby they present, I'm sorry, forgive the medical language, they present as certain illnesses, but actually underlying them are really not those illnesses, no. So they present as integrity, they're seen as lack of integrity or want of integrity or integrity deficit, but when you dig down, you realize that, no, they are just symptoms of something underlying. Now, social context misapprehension, sometimes you may want it to call it crass legalism. I won't stop you from calling it, but I won't call it that. But you've seen certain decisions that don't go down well and are perceived as emanating from want of integrity, but actually is just lack of misapprehension or miscomprehension of some social context in the art of judging, and then resorting only to legalese. But in the end, it erodes public confidence and trust in our courts. Now, like I said, the ethical dilemma issue, I will address, but this is particularly very daunting in addressing, because it's a choice between sometimes one bad outcome, one perceived bad outcome, and another perceived bad outcome. And you may have your choices, but in the end, it's a bad choice, one way or the other. We have seen that in sometimes cases whereby judges make wrong calls based on perceived religious understanding of the right and wrong, not of the law itself, a topic that itself is controversial. How do I now say it is wrong and right? So it's a big one. And We have good. So it's a big one, but we have tried again to address this issue at the UNODC, at the Judicial Integrity Network Group, and I will come to that. Now, the other one is well-being. This is a big one too, like I've said. Again, we did a survey. I will point to you to the survey at the end of it, and you'll see that it's much, much more prevalent. High media campaigns, lots of publicity on the judge, a lot of stress. Judges are human, they're human beings, and these things get to them. We've had in recent times cases of even suicide amongst judges based on these things. So this is also a challenge that needs to be addressed squarely and evidence-based addressed, so that this issue of perception of lack of integrity, or the reality of it, if you will, can be addressed. My good friend Joseph got it right. Of course, he's an expert. He's an advisor to our institute in Halifax, or is based in Halifax, the Commonwealth Judicial Education Institute, a very top-notch mental health practitioner. And the point that makes me come up with this slide is not the observation he meant about the burnout, but the fact that the well-being of the judge is actually in the interest of the public. So when we say address this issue of well-being, we're saying address the issue that threatens justice. A threat to the well-being of a judge is a threat to the dispensation of justice. Now, how do you address it? One thing I say outrightly is that correction of whatever leads to this actual lack of integrity or wrong perception of want of integrity, whatever it is, to identify them, whatever they are, identify them and correct them. But don't mask them, don't hide them. Deception is not the solution. Deception ultimately deepens the negative perception. Because like they said, fool me once, shame on me, and fool me twice. I mean, fool me once, shame on you, or something like that. There's a saying. So the moment, ultimately only truth endures. Once you take measures that mask or deceive the public, it will come out. And then it becomes even more difficult to address, to correct any wrong perception. Now, when you visit the site, you will find this survey that we did on the issue of the well-being, linkages between judicial well-being and judicial integrity. And it's an eye-opener. It's an eye-opener. I recommend that anybody interested in pursuing this thing should visit the site and look at the revelations, so to speak, that we found during the survey. Spurred by that one, recently I was one of the team that was invited to consider an international team, really, and we came up with a declaration, or a declaratory measures aimed at addressing the issue of well-being in the judiciary and justice systems. And it has come up as the narrow declaration and has been adopted, well, by some judiciaries, and it's recommended to other judiciaries also to adopt them. It's there, just Google it and you will find the entire declaration. Another point about the individual judge and the ethical dilemma, we've worked on it, and I believe in Ari's introduction, it appears to be there is a reference to that one. We have a training tool developed, 2 modules actually, the e-learning module and then the paper-based module. I recommend the e-learning one. It addresses particularly admirably the issue of ethical dilemmas. It was really professionally done. We took a lot of time at the UNODC office in Vienna. Psychologists and experts in the field were invited, we as judges and lot of work went into producing practical tests and steps whereby judges will now learn how to navigate the ethical dilemmas that they must face in their job one day or another. So at unodc.org.judicialintegrityji, you will find these training tools. You will also find the survey, and you will actually find many materials on this topic of integrity that may be useful. And I have to, in all honesty, also say that the US has been addressing it. The National Center for State Courts, with whom I've been working for quite some time now, for over a decade, I think through the Conference of Chief Judges and the Court Administrators, are also addressing it. The particular manifestations and underlying reasons may be different, but the point again is that there is waning confidence in and trust in our courts, and steps are necessary to address this waning. And the guide titled Beyond Civics Education, it's very useful. I've gone through it, and it's quite admirable. The whole concept has been that educate the public. If they understand, then they will learn, but it's much more than that. And this community engagement thing that they're proposing, I've actually done it in Borno years back with UNODC, whereby we came up with evidence-based ways of addressing some of these issues, and engaging the community is a very, very, very useful endeavor. They own it, they own the process, and you see the improvement, and the returns will be very high. So it's well thought out. So generally, the potential measures in addressing this deficit of, or perceived deficit in integrity, reform, actual improvement of justice delivery, because there is, like I said, any improvement of perception that is not based on the actual real improvement is somehow more like a deception than addressing it. So it should be, this justice delivery system must be improved as a real factor, a reality, and then be done also transparently and with accountability. All these go to engender confidence and trust in the public and citizens. Then enhance access to justice, however good it is, so long as it is not accessible to all, then you don't expect any positive feedback from the public or expectation from the public. I have to access it and use it. If it is there for others, not for me, then it's not good enough. And that doesn't say much for the integrity of the justice system. Then active promotion of well-being. Yes, that narrow declaration and the measures that were proposed are very good, and I recommend that to judges to take a look at, particularly court administrators, and see how they can adapt it to their local circumstances and use it. Training, it's essential. Continuous training, like each training module I've already referred to, whatever training that is available, both in the actual skills required, professional skills, and then even coping with the stress, and then improving communication. And then now that again goes back to what I've said is admirable in the effort being made by the Conference of Chief Judges and Court Administrators in the US. Communication is key. This is the information age. Now, particularly when it comes to communication and public engagement, I will say it should address the issue of the phenomenon of social media, and good, smart ways of projecting the court should be prioritized, not the old conventional issuing this. And so social media handles be used. I'm not saying that the courts should have their own trolls, but courts should have a way of identifying when they are being trolled, and then develop measures to address the trolling. Thank you very much. I hope I have not taken too much time on this topic. Thank you very much.
Thank you, my lord. I appreciate it. Thank you so much. We will take, because one of our speakers has to go to the airport, so we will take him before we take Judge Chara. Judge Chara, I hope you give us that permission, please.
Yes, absolutely.
Thank you so much, ma'am. Senior Advocate Okutekwa, please. Are you ready, sir?
Yes, I'm ready.
Thank you, sir.
Thank you, Dr. Ari. Thank you, my lord, the Honorable the Chief Judge of Borno State, and my lord, the Justice of Court of Appeal, my lord Justice George Will, and distinguished judges that are here, good afternoon from this part of this world. I deeply appreciate you, Dr. Ari, for the invitation extended to me to participate in this webinar. The topic, as I said, it is very profound, and we're all here today to interrogate this topic, that is judicial integrity, the combined efforts of the bar and the bench. Like my Lord, the Chief Judge of Brunei has rightly pointed out, there is a very dwindling image of judiciary all over the world, particularly in my own part of the country where I come from, Nigeria, where judges have been rated to be very low in terms of so many areas. There was a recent a publication that rated the judiciary as the highest bribe takers in Nigeria. Whether that is confirmed or not, it goes to the perception that my Lord, the Honorable the Chief Judge of Borno State spoke about. And I think that one of the fundamental reasons why there is a very low image of judicial integrity as of today is our inability to make a distinction between the code of conduct for judicial officers and the legal profession and the behaviors of other persons in our society. For instance, when I decided to read law and became a lawyer, recruitment to the bench was anchored on honesty, integrity, and candor. It must, before you are invited to come to the bench, must have been watched closely by their lordships before whom you have appeared. They watch your demeanor, they watch your character, they watch your conduct towards the bench, your relationship with your colleagues at the bar, and you must be a legal practitioner of impeccable character before you can go to the bench. Because the job of a judge is a very difficult one. It's not a job that can be taken up by a little liver person. It must be a person of impeccable character who can withstand temptations. So our judges at that time were not seen in public places. They were quartered in a place called GRA, Government Reservation Area, and you don't visit these judges anyhow. Before you can visit them, you have security agencies that are there to protect them. And the legal profession at that time that I grew up to become a lawyer about 33 years ago was the lawyers, the senior, were men and women of impeccable integrity. They were not people who aided and abated the pollution of stream of justice. Justice in its purest form was delivered by judges. You do not, at that time, you are not allowed to compromise justice. And justice in its purest, in the purest of form was served from the bench. And so at that material time, when you have erudite jurists of great repute and integrity and credibility, like my Lord Justice Niki-Tobi, the father of our Dr. Ari, spoke a lot about why a judicial officer should have impeccable character. And so I look at what my Lord Justice Niki-Tobi said, and that one of the things that has now completely brought the integrity of the judiciary to the low ebb, I think, is the politicization of appointment of judicial officers. A lot of things are going on now. Before you can become a judge in those days, if you lobby to be made a judge, you are disqualified. But today, it appears to me that what you know does not matter. It is whom you know that become fundamental in appointment of judicial officers in my own part of the country where I come from. So much so now that it appears to me that many persons who are being appointed to the bench lack the quality and character of a judge to be a judicial officer, because a judicial officer must be above board, like Caesar's wife. And so, but with the introduction of politics in Nigeria, Nigerian judges and politicians started to bring to bear their trades. And what are the trades of politicians? Partiality. And like my Lord Justice Niki-Tobi put it in one of the contributing judgments he wrote in 2008, his lordship was of the view that Nigerian judges must maintain a far distance from politicians and politics, because according to his lordship, Nigerian constitution forbids any mingling of a judge with politicians. As judge, he said, we must obey the constitution. Politics and the judgeships are not to meet, because once they meet, his lordship was of the view that the victim will be justice. And the reason is simple. The trademark of politicians is partiality, while the trademark of judicial officers is impartiality. And so the two professions do not meet. So his lordship gave all of those things. Now, for judicial integrity to be seen, as his lordship has rightly pointed out, the judge, for judiciary to have integrity, it must not only possess it, it must be seen to possess the attributes and element of independence. Today, it appears to me, from my interactions, from my practice, from my appearance in court, and from the cases I have handled, that there are some decisions that defile jurisprudential logic. For instance, in Nigeria as of today, the main thriving legal practice are political cases. And in these political cases, you will discover that time is of the essence, but interpretations of the laws, the electoral acts, the constitutions, and the rules of court appears to be hinging too much on technicality, so much so now that evidence that is produced before the court that it did not follow a set down pattern it is disregarded by the judges. For instance, under the Nigerian Constitution, if you want to file election petition, you must file it within 21 days. And you're expected that you front load the witness statements of all the witnesses you intend to call in proof of the allegation in your petition. But there is also a provisions in our law that allows for subpoena, or for witnesses to be subpoenaed. Beginning from the case of Atiku Abubakar versus INEC and P2B and INEC, the Supreme Court of Nigeria, the final court of the land, came with these decisions that did not go down with the public, that for you to competently field a subpoena witness in your petition, you must front load the witness statement of these subpoena witnesses. And the general public including lawyers, are worried that how do you front load a subpoena witness, a witness that is not under your custody, a witness that you cannot say you can bring voluntarily. And I think that those are part of the thing that the general public and some of us lawyers are saying, that as a result of this, it appears to me that our judiciary unwittingly have led themselves into the Golgotha of being slaughtered by the criticism that they got. Because if justice is to be properly served, it does not augur well for administration of justice for evidence that is brought before the court to be ignored and rejected simply on the basis of the road by which it traveled to the court. Because I know for sure that, and there is a jurisprudence, that is stolen evidence, so long as it's relevant, is pleaded, is admissible to prove the fact in issue. So part of the thing that have threatened judicial integrity also is corruption. And I've also talked about the political interferences, the lack of transparency, inadequate resources and funding of the judiciary. And for me, if the judiciary is to possess integrity, then it must be well-founded, must be impartial. The lawyers must not act as conduit pipe. So we talk about the role, what are the challenges we have in the facing judicial integrity today. There's no doubt that judiciary faces so many challenges that put its integrity into question. These challenges are political polarization and interferences, corruption and bribery, lack of diversities and representations on the bench. Today, in those days when we have the lack of Niki-Tobis, Nnamani, Tyson Elias, people were brought straight from private practice to the Supreme Court, and they did very well. Some chief judges were moved straight to the Supreme Court, like late Justice Chukwudifo Puta, the JSC of blessed memory. These were jurists of impeccable characters. They did very well. But today it appears to me that recruitment to the bench in Nigeria seems to be hereditary. You have to graduate from magistrate to the High Court, from High Court, the Court of Appeal to the Supreme Court. And even from the Court of Appeal to the Supreme Court, we have authorized the appointment to the bench. Even some of the best brains in the Court of Appeal, in the High Court. So we need diversification in the Supreme Court so that all opinions can be there because the Supreme Court is the final court of the land. Because of lack of time, I think that judicial officers themselves must ensure that they don't create opportunities for the perception to be too high that they have been compromised. And this they can do by ensuring that justice is delivered in judgments delivered. And the judiciary has the duty and to ensure that its decision is integrity-driven. Let me say in conclusion that the judiciary, and in particular the Nigerian judiciary, must avoid involving itself in partisan politics in adjudication. It is dangerous to do so. It affects badly the integrity of the judiciary. The dangerous and dirty nature of political actors in politics as it affects the judiciary was so much emphasized by late Honorable Justice Niki-Tobi, the erudite father of ARI, the organizer of this webinar. And this is because of the importance of the warning by His Lordship. Permit me to read this one in conclusion, because His Lordship was so much bittered, and he has to publicly put his own integrity on the line and say nobody can compromise him. And I do not know whether any judge, some of the judges can put their integrity on the line the way His Lordship put it. Please, I'm reading. One last word. Politics as it is played in Nigeria leaves much to be desired. There is so much acrimony, bitterness, and violence. Nigerians play politics as if they are in a battlefield. It is not so. I do not agree that politics is dirty. It is a decent game. Only some Nigerians made it dirty. The problem in Nigeria is the politics of winner takes it all. Another problem is the gain from it. I would suggest that politics should be made less attractive. Then he went on to say, in more recent times, they have involved the judiciary. Nigerian judges are called all sorts of names by litigants. They are suspected for the slightest actions. Parties do not seem to believe that judges can dispense justice in the light of the law and law alone. The insults are getting too much. Some of us has always taken the matter as one of the professional hazards. It has gone beyond that, and it is very worrying. In the administration of justice, somebody must be trusted. Why not the judges? I hate to say what I want to say to end this judgment, but I will say it. No human being, and I repeat, no human being can influence me in the performance of my judicial duties. Only God can. Fortunately, God is holy and can never make us commit sin. Let every human being get that one straight for now and forever. Despite all the insult, this court will continue to administer justice in the interest of our most cherished democracy, unquote. That's my Lord Justice Niki-Tobi saying, when in 2008, all sorts of faults and insults were piled on the judiciary in Nigeria. And that's why I say that the delusional image of Nigerian judiciary began when political cases began to come to our courts. And like my Lord Honorable Justice Amina Ogi put it, from the decision that installed P2P in power, politicians began to see the very powerful power of judiciary. And so they now began to bring to bear and brought to the judicial system their own men and women that they thought they can control. That's why I think that in conclusion, I will suggest that we must go back to basics. The recruitment process to the bench, as presently constituted, needs to be seriously looked into. When you bring a lawyer who has capacity to bribe a judicial officer while in practice, possibility exists that that lawyer, upon assumption of office on the bench, is likely to bring his conduct to play by demanding or suggesting or giving appearance that is available to be used. So for me, therefore, the bar and the bench must come together. First, we must protect the bar, the bench. And I have advocated in my contribution, which I have sent to you, that judges who are good and who have been consigned to one corner and are not allowed to be used for sound judicial decisions must be fished out and praised, not in the manner that we go to social media to do so, but we must do what we need to do to ensure that good judicial officers are not sent to one punishment zone, as it appears to be for some of the judges in our country. So I thank you very much, Ari, for the privilege. As you rightly acknowledged, I will need to go. I told you that I have to have a flight to catch. And I thank you because, let me say this publicly, that I love you. Why? Because you are keeping the light of His Lordship shining. And that's why it is good that we should have our representation. And you are representing my Lord Justice Niki-Tobi. And I'm happy that the Lordship that I hear from Nigeria are proud of you. I'm proud of you. And the good Lord will keep you. Continue to keep the flag flying, because he was an erudite and impeccable judicial officer.
Thank
and
you, sir.
There are many of them there, and I thank my Lord, the Chief
We'll
Judge.
take our next speaker.
And God bless you.
Thank you so much, sir. I appreciate it. Thank you, sir. Save Johnny back.
Thank you.
We'll go right to our next speaker, please. Judge Tar, Judge Cindy Tar, please, if you're ready, ma'am.
Yes, I am.
Thank you so much.
Thank you, Dr. Tobi. I could call you Judge Tobi, Dr. Tobi. You've had so many titles. very impressive career, and it's an honor for me to be here with you, also with Chief Judge Zana and the other very distinguished presenters and guests to share discussions about this very important topic. It's been so nice to hear the perspective of others outside my local area. And of course, so much of what Chief Judge Zana said, I can certainly understand, and it's echoed in what we see in my area, not only in the state of Arkansas, but of course in the United States. We know that judges do receive intense public scrutiny for the choices that they make. They're criticized for participating in partisan events, sometimes even certain nonpartisan events, for the types of gifts that they might accept, for comments that they may make publicly, and sometimes private comments that travel. And of course, we've seen a lot of criticism with respect to judges who have not recused in cases, and the public has not always understood the decision not to recuse. And as Chief Judge Zana pointed out, the faith in the judiciary is at an all-time low, and not just the judiciary, but also in the United States, other democratic institutions. I had also done some independent research briefly, just in terms of confidence of United States institutions as a whole, and it showed the court is only 27% of the public perceived as having confidence in the judiciary. I believe 26% in the executive branch, which is the presidency, and even a low of 8% for Congress. So I don't think the judiciary is alone in these struggles, but I know that what we are called upon here today to discuss is what we can do individually and collectively to assure the public that what we're doing as a bar and as a judiciary, that what we're doing is honest work and good work, that integrity is at the forefront of everything that we do. And again, I keep hearkening back to Chief Judge Zana, his remarks, that perception is key. And we can't always control how our decisions and how our conduct is perceived, but I believe the awareness of that is so important. And in fact, our judicial canons, I think we are not unique in Arkansas, that we not only seek to do justice, but the appearance of justice, the appearance of propriety. And I sometimes think that's where the real disconnect is because individually as a judge, I think we could examine the decisions we're called upon to make and believe that we are making those decisions honestly with an adherence to the law. But we have to be mindful that how someone perceives that decision that we believe we have rightfully made, there may be a big disconnect in that perception. I think one particular experience that I have had, which really brought this point home to me, is I have just finished a second 6-year term as an investigative panel member on the Arkansas Judicial Discipline and Disability Commission. And so I was the front line along with a public member and a lawyer. We served in panels. We were the first ones to receive the complaints that were lodged. It could be a complaint lodged by a lawyer or by a private citizen. And you see it a lot of times from a citizen standpoint, if they've been a litigant in a proceeding or as a witness in a proceeding. And I appreciate the question that was lodged right before we came on by Dr. Langbrook about transparency, and does that really make a difference? And while I was serving on this Judicial Discipline and Disability Commission, I learned from it as a judge that when a judge simply announces an outcome without perhaps taking an opportunity to explain the reasoning of the outcome, I think that type of transparency can be important in instilling the trust in the public. Whether it's an evidentiary ruling, especially when you're seeing more and more individuals who represent themselves. If they're representing themselves and they're up against a lawyer and the judge seems to be granting the objections of the lawyer, I think it's important for the judge to take the opportunity to explain, there is a rule of evidence that requires this outcome. This is the rule of evidence, because I've seen those complaints come in and those individuals don't understand that, and they believe that the judge is partial to a party or partial to a lawyer. So explaining an evidentiary ruling, I believe, is important. I remember one particular complaint coming in once from someone who came into the courtroom and they were not permitted inside. And so they couldn't see and hear the evidence. And it would have been critical, I think, for that judge at that moment to explain to that person excluded under that very unique circumstance that that was a hearing involving a foster child. And we have a very unique confidentiality for courtroom proceedings involving foster children. Every other type of court is public and open. And that person did not understand why he was being excluded. And I think a simple explanation and explaining that I'm so sorry we can't accommodate your presence in this hearing because of this particular rule that we're called upon to honor. Sometimes when you're dealing with litigants, whether represented by counsel or whether representing themselves, the outcome of a case. I've seen so many judicial complaints filed against judges because someone was on the losing end of a ruling. And if a judge simply rules in favor of one party or the other, that leaves someone without an understanding of why the judge felt compelled to rule in a certain way. So when I sat on that commission and saw the types of complaints coming in and how what we were doing was being perceived, it taught me, as then a circuit judge, I was a circuit judge for 17 years, it taught me a lesson that I needed to be more mindful of explaining what I was doing and doing it in such a way that would be understandable to a witness or to a party, what the basis was of my decision. So hopefully they were able to take away from that I was following the law and not making a ruling because I had some bias. I would also say that other things I learned from that experience, and I look forward to hearing from other lawyer presenters here, that sometimes there were complaints made because someone saw a judge and a lawyer exiting out of a particular door or entering the courtroom together. And it might have been simply that the restroom was located there and we happened to be exiting at that same location. Well, they somehow were under the impression that we were behind the scenes having some private discussion about the merits of the case. And it had not occurred to me until receiving a couple of complaints through this experience with the Judicial Discipline Commission, how that was perceived. And so I tried to be more mindful when I was dealing with lawyers and when we may have had a discussion to perhaps explain why we were together as we were, or even better, not be seen in that circumstance where something could be inferred from that might not have been correct. I think once you accept the duty and the responsibility of being a judge, you have to be willing to understand that you and the entire judiciary can be judged by your words, whether those words are sincere, by a comment that you may have made, even by an event that you attend, or clothing that you choose to wear to an event. If it's a costume party, you have to be mindful. You're not a private citizen anymore. You've taken an oath to uphold integrity of the judiciary, and the whole judiciary can be judged by your personal choices that you make. And that is something that's really been emphasized to me and something that I've learned through the years on the judiciary. I would also point out, again, in response to the question raised about transparency, and this also folds into the discussion about the media, I would say that Arkansas, and I don't know how New York handles this in some other areas, but there have been some very unfair pieces written about members of the judiciary based on decisions that were made. And Arkansas has a commission that has been formed to respond to unfair criticism of the judiciary. And where I saw this most often as a trial judge it seemed that the public would not understand. Of course, they're reading this article that has been written, and the article was written based on perhaps an affidavit or a police report that was in an open court file. And the article would seem to want to tie together the initial complaint about allegations against an individual and the unfairness in the ultimate outcome of that proceeding, whether it be through a guilty plea, whether that be through a trial or a bench trial. We sometimes find that the newspaper doesn't always report what happens in between those two important parts of a case. The newspaper article doesn't always do the digging to know that a witness may not be available any longer for a trial, or that there may have been some other reasons why the allegations that were initially made didn't materialize into the type of outcome that they were expecting. And so this commission in the state of Arkansas made up of some attorneys and some judges, and others were able to respond to that unfair criticism, because again, the perception of that outcome is what people believe are the reality about what has occurred, and they lose confidence in the judiciary when they don't understand the full picture. And so I believe transparency, I don't believe judges need to be in the middle of that. I do think that that can sometimes go very poorly for the judiciary, but I believe some transparency by someone who's able to ethically comment on those proceedings is really important. I am trying to be mindful of my time, Judge, so I catch myself talking quickly. I would also say this on the brief topic earlier about how judges are chosen. Arkansas has judges that are chosen both by election, and we are nonpartisan when we do run for office in Arkansas. There are also opportunities, especially when there are vacancies in the judiciary, for a governor to be able to appoint someone to that vacancy. And the public pays attention to those appointees. The public pays attention to what these candidates for judicial office say and who they're with when they're running for office. The public is smart. They understand if a nonpartisan candidate is seen in the company of a lot of partisan individuals, that perhaps that candidate doesn't look so partisan anymore. And I think that's been a part of what's been the problem with some of the United States Supreme Court justices, or some of those comments made in attendance at certain events that may appear to be partisan. I think there's a real opportunity there for those bodies or for the governors who appoint judges to take that opportunity to appoint someone who's perceived as nonpartisan. I think of a particular Arkansas appointment several years ago by a governor, and the governor chose someone who was a very, very well respected ethics professor at one of our law schools in Arkansas. He had written books and taught courses on judicial ethics and lawyers' ethics, and was not partisan, had not been recently affiliated with a particular party. That appointment was really perceived as such an honorable appointment, and I think was such a good perception of our judiciary, and in fact the governor as well. And it's important for governors and other bodies who make those appointments to recognize what a good service that can be to the perception of the judiciary and to the appointing body when they're choosing someone who is perceived as nonpartisan. So I know with those comments, I've covered a lot of different things, and I've gone back and forth trying to hit on some of the high points, but I again want to say what an honor it has been to be here with you, Dr. Tobi, and with the other esteemed presenters and those in attendance. It's a very important topic, and I'm honored to be able to make a contribution. Thank you so much.
Thank you, Judge Chair. Thank you so much for your contributions. We'll go right to the next speaker. Attorney Washman, please. Thank you, ma'am.
Thank you, everybody, for having me here today. I'm very excited to be part of this esteemed panel. It's been very interesting to hear what it's like in other countries. I'm a small town girl from Las Vegas, Nevada, and I made it to big New York and am the leader of a bar association, which is pretty shocking given where I came from. So I wanted to just talk to you about what it's like to be representing a bar association and what goes into it, and insofar as judicial screening and things like that. So I want to give you a little bit of history about me so that you can understand the personal feelings that we bring to the organization and when we're doing judicial screening. So I am the 44th president of WBASNY, and we are the largest women's bar association in the United States and is made up of over 4,000 members. Our organization includes attorneys, judges, educators, and others in the legal profession. WBASNY's mission is to promote the advancement of the status of women in society and of women in the legal profession, to promote the fair and equal administration of justice, and to act as a unified voice for its members with respect to issues of statewide, national, and international significance for women generally and for women attorneys in particular. After I graduated law school, my husband and I founded our law firm Schreier and Waxman. Shortly thereafter, I was invited to join a trial lawyer's online listserv. The listserv changed the course of my life. I met friends and mentors through the listserv and eventually met judges. I was also introduced to bar associations. I did not know why a bar association was important. I learned that it is not only great professionally, because you will meet judges, perhaps find a mentor, find a job, network, and learn how to present yourself in court. But it is also a means to make lifelong friendships, including those with judges. I had joined the Brooklyn Women's Bar Association, which is one chapter of the State Bar Association, to which I'm a president of now. After I joined the Brooklyn Women's Bar Association at the state level, I joined the legislation committee. And a few years later, I became a co-chair. And as a co-chair of legislation, I work with lobbyists to better the lives of women and girls in the state of New York. And we handled many pieces of legislation that were devoted to protecting the rights of women and children and families, reproductive rights, victims of sex trafficking. We did bills to combat discrimination. And this year we have the New York Equal Rights Amendment on our ballot, and we hope that people will vote for that. People ask, why do we need a women's bar? WBASNY makes change happen. WBASNY is a women's organization whose efforts elevate women in the legal profession to get judgeships to ensure a diverse bench. A diverse bench is proving that it makes a difference. I have sat on many independent screening panels to consider candidates for courts in New York, from the top courts to the lowest courts. This is where people who want to become a judge or elevate to become a judge to sit on a higher court fill out an application, then we investigate them and we interview them. By participating in panels, we are meeting people before they become a judge, and then they see you have the power to elevate them or make them a judge. I have many judge friends from meeting them through the screening panel process throughout the years. Our organization receives invitation to designate a member to serve on the screening panel. I choose people to screen other people. The concept of the screening panel process is to have impartial panels made up of people well-equipped to consider the qualifications of candidates for the court. When we do our investigations, we see sometimes that the applications are not accurate, or in other words, not truthful. We also see why the candidate judge may have been admonished. Some of the behavior judges demonstrate during their time off the bench comes back to haunt them on the bench. For instance, a judge recently was filmed when she was threatening to shoot people who were on the property that she was a guest at because she didn't like what they looked like. She is now having a time out. That is a pretty bad thing to be doing. Judges are judges when they're on and off the bench, and sometimes judges forget and conduct themselves as humans and demonstrate bad behavior and make bad decisions. During the screening process, the interview is very important. The candidate is on the hot seat where difficult questions are being asked. We recently had somebody come on and we asked them, how do you make your decisions? What goes into making your decision? She was so nervous that she kept saying, well, I look at the law and when I'm not sure, I go back and I look at the law some more. And then I go and I look again. Well, the response from the panel was, this person can't make a decision. As a judge, you have to make a decision. It's just the way it goes. And later in time, I did see her on the bench. She did end up on the bench. And I had a case in front of her regarding discrimination in a restaurant. And I said to her, I said, you know, you're gonna have to make a decision. So she says, I'm ready to make the decision. And we went forward. It was great. So in addition to the screening process, as bar associations and bar leaders, we hold many events together with judges and for them and with them. And it helps the bench and bar move closer to each other to build confidence among the bar in the judicial system. Because now we're meeting judges in social settings where you really get to know them as a person and a judge. And you know what, it's a lot easier to appear in front of the court when you've seen them in a social setting, because it takes the frightening part of, well, gee, we don't know this person. We don't know how they're going to behave. And it takes all those mysteries away, which is really wonderful for the bench. I have also presented to the Women in the Courts Committee, which is made up of female judges statewide, regarding the lack of value of women's work in the home and the devaluation of it. Having the bar come to speak to the bench also helps to build relationships and trust. Overall, my experience in court has been pretty good, and I believe the judges have been fair and have demonstrated good judicial temperament. I've only had one instance where a judge recused themselves. I didn't think that he needed to. I have a case against Madison Square Garden, which is a pretty big entity here in New York. And part of the owner's way of dealing with the attorneys who sue them is to ban them from their venues. So I'm an attorney that proudly has been banned from this particular venue. And the judge on the case decided to recuse himself. And it was posted on the court link that he was recusing himself because somebody in his court is married to somebody who works at the venue. Well, I think that's a very noble of the judge, but it's 10 steps away, 10 degrees away from where I think somebody should be recusing themselves. It wasn't based on a relationship with me or any of the parties or anything like that. But so here in New York, I think that the judges are very concerned about being perceived as not doing the right thing, or if they felt that, if they think that they're going to want to elevate because this particular judge is a lower court judge trying to move up, they don't want to have any inkling of a problem come back to haunt them. So I just want to talk to you about my clients. My clients all believe the fix is in against them. They think all the judges are on take and they're all taking bribes. And there's no way that we're going to win because the judges are all on the take and they don't care about the little people. They only care about the insurance companies and they care about where they're going to get elected and who's going to get them elected. And they don't care about the little people. The perception by the public is that the bench is corrupt. So I have told you that most of the time I go to court, I've not had any issues. I was not always a bar leader. And as a bar leader, it's gotten a lot better for me. I'm not going to deny that. But I do have a case I do want to talk to you about, which was really very upsetting. And I felt that the fix was in, and I also felt that the judge was corrupt. I had a client who was riding his motorcycle on his way to work, and he was going to work at night. And as he was riding his motorcycle, there was a down power line, which he could not see, hung him by the neck. He held onto his motorcycle and slammed into a pole and broke 1 million bones in his body. Okay, now I get hired and I'm doing the investigation. All of the evidence has been destroyed. There's no evidence. There's no reports. There's no nothing. The police department puts my client in a different location than what he really was. The 911 tapes are missing. All kinds of, the whole picture of this didn't pass any smell test that I had ever taken. And now we're in court and I'm arguing to the judge, we need the evidence. We need depositions. We need to move our case. And the court was blocking us too. Whatever you got, that's enough. You're not getting any more. You're not getting any more. They said, but Your Honor, We listed 10 different defendants because we don't know whose wire it is. We don't know who was maintaining a tree who had fallen. We don't know this, we don't know that. Do you know the court would not allow us to depose every single named party? It was really something else. So then I'm thinking, the fix is in. The judge is leaving the courtroom with the defense attorney. The judge is calling the defense attorney by the first name. I don't know this judge, but this judge definitely knows my opponent. Yeah. But as a good investigator, there's this thing in New York called the Freedom of Information Law. The Freedom of Information Law was my friend in this case. I was able to find the reports that they filed with the state public authorities because they had to file them. I was able to discover all kinds of testimony and all kinds of affidavits and things that were available through the Freedom of Information Law, but the court was blocking me from getting. I ended up getting ready to pick a jury and they settled, but it really left a bad taste in my mouth with respect to the way that this judge handled herself, given the tremendous injuries that we had in my case. So it goes back to, was she worried about being elected? Was she worried about her, the utilities, which is maybe they give a lot of money to the judges insofar as when they're running for election. It didn't seem right to me. So insofar as transparency goes, I would love to know in a situation like this, what was really going on behind the scenes. And if I wasn't so dogged about making sure my client received justice, he would have been hometown and would have lost. Thank you again for including me today.
Thank you so much, ma'am. We appreciate it. We have just little time, so we'll just go right to our last speaker, Dr. Longbrook, please. Thank you. I'll take our questions then. Please send your questions in, please. Thank you.
So, good morning, good afternoon. Well, I'm very honored to be able to contribute to this meeting. Thank you very much. During all the presentations, I had the urge to enter into a conversation with the presenters, but unfortunately that was not possible. But I would like to announce that I don't mind being interrupted when I'm talking. I prefer a decent conversation instead of me only sending something. So that first. And another thing is, I will not use a PowerPoint presentation. We have a comedian from Belgium in this area of the world, and he mocked PowerPoint, and he mocked PowerPoint very effectively by imposing himself as Martin Luther King delivering the "I have a dream" speech by using a PowerPoint. And I can assure you that was absolutely hilarious. And so I won't use a PowerPoint. I will try to react also to other speakers so far that I have heard so far. First of all, I would like to go back to the original subject of this meeting, and that's judicial integrity. And look, this is one of the most difficult subjects to do. It's about the person of the judge, and I think that Ms. Waxman has indicated that perfectly, and also the other speakers talked about the selection of judges, the personality of judges, the good character of judges, and that's all good and true. But that's not enough. During the past 5 years, I was involved in several projects to help the Ukrainian judiciary improve in their functioning. And one of the largest concerns in Ukraine is the endemic corruption of everything and everybody. So 5 years ago, you could say that Ukraine was in a corruption pit. And that means that it's almost impossible to get out of it because everybody is used to it. So if you get a fine from a police officer, you pay something and then you don't get a fine. So if you want to have a nice decision from a court, you bribe the judge. If you go to a notary, you have to pay something extra. If you go to a doctor or to a hospital, you have to pay something extra. Everybody does it. If you want to have a license for anything, you pay something extra. If you want to have a nice diploma from a university, you pay the teacher and the lecturer. So that was very difficult. So, and then where do you start to help improve the functioning of the judiciary? Well, I find it always very hard to tell people directly in their face, well, I think you're corrupt, without any evidence. So we couldn't do that. It would be very harsh and it would be very impolite. And it would not be very stimulating for them to pick up and try to improve. So one of the things we tried to do at first was because integrity is not only about what you do outside the court, it's also about what you do inside the court. And so it's also about organization development, so to speak. And when you look at, let's say, the judicial culture in Ukraine, it's related to, let's say, the old Soviet Union culture. And it means that so they have a very legalistic approach to law. So the idea of judicial discretion is very scary for them. Why? Because there's also a strict disciplinary hierarchy, and that induced judges to behave like, well, if I do not get an explicit instruction to do something, I do not do anything. I will not do anything. I just will mechanically apply the law, even when the law is not clear. And when there is a sensitive case, then and I am assigned to that case, then any argument to recuse yourself from the case is valuable. So they had the culture of throwing the hot potato over the wall to their dear colleagues. And they also did not trust their own colleagues, because everybody could be your enemy and everybody could report you to the disciplinary authority. So judges would be afraid to develop their own initiative, to take initiatives to improve the functioning of their courts. And what that also meant in the relationship with the bar and with lawyers, that would be that they would leave the development of the trial to the lawyers. And that makes life for judges very difficult, because the court plans the hearing of a case, and it plans only so much time in the courtroom. For example, for a simple case, 30 minutes, for a more complex case, an hour, and for a really complex case, several days. But when the lawyers do not stick to the speaking times, the whole planning of the court on that day and on the other days goes berserk. And everybody else has to wait. They use electronics, they use WhatsApp, But still, if you go to a court in Ukraine, you can see a lot of lawyers waiting in the corridors. The same is the amount of how large can the papers be that are being transmitted to the court. If you have a written plea, can that be 100 pages? Should it be only 8 pages? So the more pages, the more time the judge needs to read. And the less time the judge can spend on other cases. Everybody else has to wait because of that. So it's quite, let's say, from a logical perspective, it would be quite all right if the court would put limits to the speaking times of lawyers, to the size of documents the lawyers submit. But also, it would be also quite all right to limit the way and the reasons for which lawyers ask for postponements of the hearing, especially when it's at a late moment. Because when it's at a late moment, the court is almost not possible to fill the open space in the courtroom. And which means, so you get your postponement for your case, but then the court loses capacity. Why is this important? This is important because the court provides for a public service. And it's usually paid by public money, by taxpayers' money. So then it is also very reasonable that the court assigns its time in proportion to the cases that are, to the character of the cases that have been filed. So this type of proportionality, because that's it, is also then part of the organizational ethics. How can you organize improvement in such a case as in Ukraine? Well, first of all, is make the judges talk with each other. And you say, are you crazy? Yeah, but they didn't talk with each other. They would only talk with each other when they would be in a multi-judge panel. And so the organization would only be top down. But if you want to have to create integrity as part of the organizational culture, you need to create the possibility of judges to trust each other and to talk with each other about everyday dilemmas. And there are everyday dilemmas in all the courts everywhere in the world. And you need to be able to discuss that on a regular basis. There will always be cases. No doubt you are familiar with the one business is trying to harass another business because they are both in competition for a contract, for a large contract. And if the one company is small and rich and the other company is but one company is large and rich and the other company is small and upcoming, then there's a power difference. So then it can be quite effective to harass the smaller business with a court case, and then instruct the lawyer to postpone the case as much as possible, at least until the decision on the contract has been taken. So you can say, yeah, that's an abuse of proceedings. But you can also say, yeah, but it's a procedure that is being filed by the larger business. And especially in countries like Ukraine, but another country where this happens is Greece, businesses can use procedures to, well, make their adversaries very unhappy, just by trying to win the case, but by filing the procedure and trying to keep the procedure ongoing forever. And then the question is, what can you do about it? I'm an academic, so I'm dealing in questions and not in answers. Sorry. But there's so many different cases, and the inventiveness of the people who try to have their way by abusing the justice system is endless. If you want to learn of how to bribe, you can learn a lot from people in Ukraine. They are very clever. They are extremely clever. And then I come to the transparency debate. In Ukraine, when you are a civil servant, you want to become a civil servant, and also when you want to be appointed as a judge, you need to declare all your possessions, your real estate, your car, your bank accounts, etc., in a public registry. The registry is public, and it is going to be connected with the land registry, etc., so that everybody can see if you in how far you lied or withheld any information. And I can assure you that there have been judges who could not explain how they became owners of a hotel chain, for example. And so during the past years, they lost their job because of that. So there has been a cleaning effort. But the transparency is absolute. The transparency is also about who you were married with, or how your living is, where your children go to school, etc., etc. So it's quite absolute, and that means that a judge does not have any privacy, almost does not have any privacy in Ukraine. That's quite something, you know. I understand why they do it in this way, because the corruption of the judiciary is endemic. And to a certain extent, if you look at the numbers on public trust in the courts, it has been effective because public trust has risen from 10% to almost 20% in Ukraine during the past 5 years. So that's an improvement. But 20% is still a very low number. Now, what can you do? What can you do? Well, what we did in our project, we connected with the judges. So first we went to the Odessa Oblast, and there are about 11 courts in Odessa Oblast. And we made a tour of all the courts, and we asked them, would you like to participate in our project? And they said yes. And so we started to organize meetings. And with these judges, and we explained to them what our intention was, and that we would like to discuss with them about the work. The method is called appreciative inquiry. I don't know if you're familiar with that method, but you can look it up at the internet if you like. And we asked them, well, what rules would you like to make for your judicial logistics, for your court logistics? And so the first thing they came up with said, yeah, well, we want to limit the recusals because it drives us mad. And so they came up with a set of rules about recusals. And the rules would be a list of arguments that are not valid when you want to recuse yourself. So the argument that you studied with someone and who is a lawyer of a party, that's not a valid argument to recuse yourself. The argument that you sit regularly in the bus with someone or in the train is not a valid argument to recuse yourself. The argument that your children share the school with one of the lawyers in the court is not a valid argument to recuse yourself. You know, this type of, well, quite reasonable discharging of argumentations. And then we and what was amazing for us, because we did not have high expectations, they started to write these, what we call procedural guidelines. And they started to discuss that amongst themselves for criminal cases, for civil cases, commercial cases, administrative cases, because basically Ukraine is a civil law system. And we repeated that later on in Kiev, in the district of Kiev, and also quite successful. And we repeated that with judicial ethics. And because at the basis of judicial ethics should be, that's our perspective, my perception, the daily conversation about all kinds of things, of judicial dilemmas. And that also has been, until now, very successful. And then the next step, when they have accepted the idea, is ask them the question, how would you like to organize that this conversation about procedural guidelines, about judicial ethics, is going to be continued in your court? Do you have any suggestion? And because they are smart people, of course they come up with suggestions. And then, well, we had a conversation with them about it, but then, and what we're now trying to do is we try to stimulate them and to help them get that organized in the courts, also by involving, let's say, the hierarchical authorities. And they have an inclination to do it and to accept it, because Ukraine and the entirety of Ukraine society is under a huge amount of pressure. And everything becomes fluid under so much pressure. And so also in the Ukrainian judiciary, the window of opportunity for normal organization development, for developing judicial ethics, is now. Thank you very much.
Thank you so much. Sorry that we didn't have much time to go on with these very intelligent and insightful contributions. We really appreciate all of you. Before we just go on, I mean, everybody has said the most important key words and terms about judicial integrity, the importance, how the judges need to pay attention to what is perceived and more than what, you know, they believe themselves, that you have integrity is not as important as how you are perceived to have that integrity. Of course, we can see from that was Chief Justice Zana's presentation, and we can see that from Mrs. Washman's encounter, that the perception is very important. And also Judge Tara saying that, you know, the fact that a judge and a lawyer can be going to the same restroom may be perceived wrongly. So there's a mindset that judges have to have. And we kind of really appreciate also S.A.N. Okutekpa's contributions on what he feels and believes that the judiciary of Nigeria should do to keep themselves away from politicians and from suspicious activities. And of course, the last speaker also telling us, which is issues of case management, case flow. The lawyers, you know, judicial time is justice, like S.A.N. Okutekpa has said. You know, when there's no justice, when justice is not done, then the integrity of the court is questioned, right? So where you do not have the time for judicial matters and people do not even understand what you're saying or your explanation. Example, Judge Tara said, it's also important to explain to litigants judicial procedures, evidential rules. And if you don't have the time, because lawyers have taken half of all of that time away, then justice is being challenged. So thank you all so much. If you have a question or two, we would like to open the floor for a question or two or a comment, then we would close, please. Thank you. Yes, sir, please.
Okay, I would like to, thank you. I would like to, to continue the conversation about transparency. Considering what I heard, I don't think I disagree with being transparent about the reasons for a certain decision and explaining it to the parties. I think it's very important, and the way you explain it is also very important. We had a case here in the Netherlands about a drunk driver who killed grandparents with their grandchild. So the family of the deceased were present in the courtroom, and the judge was just sitting there, and she was reading the judgment like this, and she had no contact with the family of the deceased in the courtroom at all. She didn't look at it, and she was reading out loud, which was, and even content-wise, the judgment was defensible. The way she conveyed the judgment was very, well, impolite, and someone from the audience, while she was reading out loud, became so angry that he threw a chair to her. The person was removed from the courtroom afterwards, but was completely understandable that he became so angry. So, no misunderstanding about that. But there's also a different kind of transparency. It's the transparency about how the court functions. It's the transparency about how judges are selected and elected or appointed. And there's also the transparency of the relationship between the court and the media, and the behavior of the court on the socials, and the behavior of judges on the socials. So how much transparency is good, so to speak? And that's a difficult question, because, and now I'm trying to make my point. Judges can only speak through their judgments. Judges are not going to debate their judgments with another audience, with journalists or with lawyers or whatever. They will not do that. So in a way, you have to keep up your authority. And that's why in most countries, judges sit in the courtroom, sit a little bit higher, and you wear a gown. And so that means that what you are doing as a judge is something impersonal. It's delivering justice. So, and it's symbolically, it's highly relevant. So all your behavior has to, support that symbolic position. And in this way, you support your authority. Everything is related to that. That's why that's one of the reasons why I think it's a very difficult to be and to perform well as a judge. It's also not something that you should be left to yourself, but it's also something that you can organize with your judges in the same courts. It's something to discuss with each other. It's not something that you can do yourself. Thank you.
Thank you so much, sir. Anybody has any questions or comments? From the comments that were passed, some participants had mentioned, what they wanted to know, and I believe that some of the speakers have covered that. I have a hand up, Judge Brian Burns. Thank you, sir, for joining us.
Thank you.
Yes, sir.
I've been
Judge Brian Burns is the judge of the Supreme Court of New York State. Thank you, sir, for joining us.
Thank you. I've been on the bench for over 20 years, and this was the most interesting and comprehensive discussion of judicial integrity that I've had the privilege of attending. So I want to thank you and the fellow speakers, and tell you how much I appreciate the opportunity just to listen to your words. My final comment is to Attorney Waxman. I just loved her comment that when attorneys and judges can sit together in appropriate social settings, it brings the bar on the bench closer. And it's so ironic because as of a week and a half ago, I had never met her. And a week ago, my wife and I had dinner with her and her husband at an event for another judge. And I apologize for having to leave early, but Dr. Toby had me involved with another event later that night. So I cannot believe what a small world this has been.
It is. Thank you so much, sir. Yes, we have Dr. Samuel, on your way to getting the doctoral, Dr. Samuel Jamuliro, a PhD candidate. Yes, sir, please.
Hello, greetings to everybody. I'm here to thank all the presenters for the work well presented, and my greetings to everybody. Thank you.
Thank you. That's from Uganda. So, yes, my Honorable Chief Justice Zana wants to make a comment or response, please. Thank you.
Yes, thank you very much. I need to go, so that's why I raised my hands.
Okay, sir. We're actually about to we're done.
Well, because I've seen a question actually on this thing that I believe Dr. Longbrook has for me on the transparency issue. But before I handle that, maybe I should apologize to him for using PowerPoint. And I assure him I'm not a comedian. I only happen to be a judicial educator. And like you've said in the introduction, I'm president of the Commonwealth Judicial Education Institute, and we have really well-informed studies on how to communicate and what aids communication, what aids retention, what aids delivery. And it is in that context that I used my PowerPoints. And if anybody laughed, I will be rated very well at Halifax for doing very well, because easing the tension allows for assimilation of knowledge and the communication. So I apologize for using PowerPoint. As for transparency issue, the point about transparency is not just the judge. We're talking about the institution too. There are other processes involved that impact on the building or sustenance of public trust. What about the appointment process of judges? Transparency in that process engenders trust and confidence. What about how petitions or complaints against judges are handled? If that is done in a transparent manner and a transparent procedure is employed, that endangers confidence and trust in the justice system and in the judiciary as a whole. And indeed, as the point was made by, thankfully, by other speakers too, in the judging too, where it affects the individual judge too, where the decision is clearly explainable and understood, it engenders transparency. It engenders trust and confidence in the judge and in the judicial system as a whole. So this is the context we use. Transparency and accountability is really wide, and it's not a restrictive, it's not a narrow angle. And if I have your permission, please, I have a meeting for 3 o'clock, and you can see I'm late. I've sought permission for them to wait for me, but I hate to.
Thank you so much, sir. We are actually ended. Thank you, and God bless everyone. Thank you so much. The 10th edition would be hopefully 5th of December, and we're hoping that we have approval from our guests to put on the invitations soon. Thank you all, and God bless.
Thank you.